Hello and welcome to today's webinar. We have a great presentation lined up for you today, but before we get started, there are just a few general admin points to cover. First and foremost, please use the online question tool to post any questions that you have and we will share them with our speakers. Second, if you experience any technical difficulties today, please let us know in that same question tool and we will do our best to resolve them. And finally, just to note, the recording of this session will be shared via email in the coming days. So, without further ado, I'd like to hand over to our speakers.
Good morning. I'm Dave Holley and a partner at the Compliance and Investigations Consultancy Stone Turn Group. I'm fortunate to have an exceptional panel of practitioners with individual focuses in different regions of the world to discuss sanctions compliance, best practice, and provide a vision of where we are headed in terms of sanctions. I've been working with clients the past 30 years on due diligence, compliance, investigative matters. I served as an independent compliance monitor to a financial institution under regulatory order for sanctions compliance lapses. And I'm incredibly eager to hear from our three practitioners and learn, and hopefully you will too. And with that, I'll turn it over to Sue.
Hi, my name is Sue Millar. I'm sorry I'm not on video. We had a last-minute IT hitch. I'm a litigation partner at Stevenson Harwood, and I'm head of the sanctions group here. And I've been working on sanctions-related matters since around 2008, when the main target of sanctions was Iran.
Barbara?
Thanks, David. Yes, happy to be joining all of you today. I'm Barbara Linney. I'm a partner in the Washington, D.C. office of the law firm of Baker and Hostetler, where I co-lead the firm's international trade and national security practice team. I've been advising both U.S. and international clients in the sanctions and export controls area for, well, I hate to admit it, but it's almost 30 years now. Every year that goes by brings new and interesting challenges, and I'm looking forward to discussing this year's biggest challenge with all of you today.
And Roland.
Yes, thank you. I'm looking very much forward to this webinar today. My name is Roland Stein, and I'm based in Berlin. I started not 30 years ago, but around 2006 when I started at Freshfields, then where I worked around export control and sanctions and other international trade matters. Then in 2016, I co-founded Blomstein, and we're a boutique law firm focused on international trade and also public procurement and antitrust, but I'm really focused on export control and sanctions, from North Korea, Libya, now a lot of Iran and mostly Russia, really. That's it from me.
Thank you. So the full count of new US, UK, and EU sanctions levied against Russian-related programs, I read totaled over 2,300 in the first 40 days of the invasion of Ukraine. We've seen multilateral sanctions targeting people, entities, ports of embarkment, expansive trade restrictions covering the incredible minutia of dual-use goods, airspace, technologies, export controls, and more. So this continuously evolving list of potential global sanctions, violations tied to Russia and Belarus, goods banned by the Bureau of Industry and Security, is continually developing, probably even this morning. I haven't looked, but I'm sure that's the case. I'm going to ask each of the panelists to provide an overview of their respective sanctions regimes as they currently sit today, or better yesterday, because again, who knows what's happened today. Roland, can you give us an overview of the EU and where things are?
Yeah, sure. I think, it really has been a substantial change. I think no one here in the EU thought that this type of sanctions would ever be possible against such a major economy such as the Russian one. And our, German Chancellor Olaf Scholz was not known to be particularly, fond of great speeches. He phrased the term Zeitenwende, which is, a new era, a change of eras. And this is a term that has been used here in Germany, and I think also in a number of other European countries to really show how great the separation from the Russian economy has been in the EU. And David, as you rightly said, the pace of these changes is impressive. And for the objects of these sanctions, it's really, the companies on all sides, it's really extremely difficult to try to cope with these changes. And even companies that took the decision to unilaterally and completely separate from the Russian market still have to deal with these sanctions. For example, if they still have service contracts or have former employees, walking around in Russia. So I think it's really difficult to completely separate. If you look at it as it is now or yesterday, I think there is hardly any sector of the economy that has not been touched. I think the first issue was we had export restrictions, which basically went on to the export restrictions that we already had because of the Crimea invasion back in 2014. And basically the sectors were broadened to have more technology, any technology that could in any way be used in the military sector. What followed then were the so-called smart sanctions, at least that's how they're called. So we had financial market restrictions, import bans on freight transport, public procurement procedures. So somehow also quite unique sanctions that we haven't seen so far. And something that we've only seen in a comparable manner in the North Korea sanctions were the luxury goods ban, which naturally encompasses the big luxury cars and perfumes, but also rubber dinghies and underground trains, which probably wouldn't be perceived to be luxury goods, but which are still caught by these sanctions. And then an issue that has now, the closer the winter gets, it gets more and more importance is the import of energy products, so power, oil, gas from Russia, which is seen quite, with an amount of controversy by EU member states. And while some still depend heavily on Russian oil and gas, or that's different seen in other countries. So I guess that's an area where we'll see more movement in the coming months. I guess that's what we have in the EU in a nutshell.
Thank you, Roland. Sue, how about your perspective from the UK and the sanctions evolving there?
Yeah, the UK has been a very active proponent of targeted sanctions against Russia following its invasion of Ukraine. Although the pace has slowed, we've not previously seen sanctions being imposed at such speed and scale. It seems to me that the EU has been leading the pack with 7 packages of sanctions being introduced, whilst the UK has pre-announced lots of sanctions, e.g. deposit, investments, services and trust prohibitions, with very long delays in their implementation. The deposit and trust prohibitions, as far as I'm aware, not yet been published many months after they were first announced. As you would expect, the B word has played a role in some divergences, namely Brexit, between the EU and UK regimes following the latter's exit from the EU. Chief among them is the EU's convergence with the US position in relation to the aggregation of shareholdings when considering ownership of companies by one or more sanctioned persons. The EU and US aggregate shareholdings so that if 2 or more designated persons hold more than 51% or more of the shares in a company, that company's assets are frozen. The UK does not aggregate shareholdings unless there are grounds for believing that the designated persons are acting in tandem. One positive change to come out of Brexit is the UK's ability to issue general licenses to deal with common situations, similarly to the US. The EU is only able to issue derogations licenses in respect of specific situations, and that was confirmed in one of the cases that my firm did when we were challenging EU designations in respect of a German-owned Iranian bank. In respect of FAQs, the EU and the US publish them to offer guidance. The UK doesn't routinely do so, but OFSI has indicated at a recent webinar that it was looking to do so. OFSI is in charge of financial sanctions implementation and enforcement. DIT, the Department for International Trade, and the Export Control Joint Unit implement and enforce trade sanctions. So I'm querying whether OFSI was also speaking for the latter. Most people will appreciate this already, but it's important to know that it's not possible to read across the various sanctions regimes. For example, both the EU and UK regimes contain reporting requirements, but they apply in very different ways. In the EU, they apply to individuals, but in the UK, they apply only to relevant firms as defined. That's mainly the regulated sector. Another example is the EU and UK prohibitions on the importation of revenue-generating goods. In the EU, some of them at least, mainly those in relation to raw materials for making fertilizers, that's potash, are subject to importation volume caps. In the UK, the prohibition is absolute, and there are no caps in place, say, for example, the normal derogations in relation to humanitarian grounds, which seems somewhat backward and is and in my view is inevitably negatively impacting UK producers. Another area of difference is the ability to challenge designations. In the UK, this is now done by judicial review, which puts a higher evidential threshold on the government to justify its decision to designate an individual or entity. But I do query whether the proportionality test, one of the fundamental principles of EU law, remains.
Thank you,
And
Sue.
that's all I was intending to say at the very beginning.
Thank you. Barbara, in the US, where are we and what are we seeing here?
Okay. Well, like the EU and the UK, of course, the US has implemented a wide array of both sanctions and import-export controls, or trade sanctions, as Sue has referred to them, against Russia and Belarus. And I think we're probably at this point just about as close as you can possibly get to a comprehensive embargo without actually being a comprehensive embargo, both from a sanctions and a trade controls perspective. And so, the result is that companies, I think, have to stop and think, wait a minute, if this involves Russia, let's first determine whether this is something we can do, as opposed to being able to hold in your head a checklist of 5 or 10 things that you can't do, and be fairly certain about whether a particular transaction is on that list or not. As Roland and Sue have noted, the U.S. response differs in various details from both the EU and the UK responses. And so I think that, whereas in broad terms, we can all say that the global response was both swift and multilateral in this particular case, these differences in scope and implementation continue to be very challenging for companies, particularly for companies who are doing business in or with a number of jurisdictions. And of course, let's not forget that, here today on this program, we're talking about the EU, the UK, and the US as being the jurisdictions that have implemented fairly significant programs, but other countries, Canada, Australia, Japan, just to name a few, have also responded in a fairly significant way with their own laws and regulations. And so this need to try to understand and manage transactions across a wide variety of jurisdictions and laws and regulations is an important aspect of the challenges that are faced by U.S. and global businesses. With respect to the U.S., we heard briefly from Sue about the various agencies that are involved in on the UK side in terms of implementing these various restrictions. And the US is also challenged by a number of different US government agencies that have a role in this process. On the export control side, we really have two key agencies. That's leaving aside things like, nuclear related exports, which are handled by yet another set of agencies. But interestingly, the Directorate of Defense Trade Controls at the U.S. Department of State, which administers our military export controls, had actually imposed an arms embargo against Russia back in the spring of 2001 for different reasons, but there is that arms embargo there, so that most of the activity this year on the export control side ended up being via the Bureau of Security, or BIS, at the Commerce Department. I wonder if we could maybe suggest that when people are not speaking, we could mute ourselves. I'm hearing a lot of feedback. Thank you. And then, of course, other controls, financial, transactional, etc., which are implemented primarily by OFAC at the Treasury Department. Of course, OFAC is the agency that most people would be familiar with when it comes to sanctions. And in fact, I think a lot of people who are charged with operating compliance programs within companies who are principally used to dealing with sanctions issues found this sort of plethora of export controls to be a real challenge when that was sort of laid on top of the sanctions response. OFAC has really actually 4 different programs that it operates with respect to Russia. One of the things we did in the early days was implement a resource center on our website, simply because there was no, and there still isn't, any one sort of U.S. government source that companies can go to find out about all the various different controls that apply. Ultimately, OFAC did create a sort of one landing page from which you can get to all 4 of its programs. There was a lot of confusion about that previously to that. And BIS has implemented a sort of page that brings together links to all the actions it's taken. But again, as I said, as of today, there's no sort of one-stop shopping, so that makes it all the more confusing for compliance personnel and companies who are trying to navigate this process. Just a couple of more notes. I think, and Roland mentioned that a lot of companies just simply decided not to do business with or in Russia. That was their way of coping with this. I think in many cases that was because the cost of compliance was so high and the risk of violation was so high compared to the benefits of the remaining opportunities. But then, you did have a whole category of exporters who I think reacted more from probably a branding perspective than anything else, because one of the phenomena that we saw in connection with the Russia sanctions was this tremendous effort to sort of name and shame companies who continue to do business in Russia, even if that business was lawful under any applicable sanctions or export control laws and regulations. But then, you're left with this sort of quite a bit smaller cadre of companies who are still trying to do business in or with Russia if it's lawful. And of course, the challenges around making that determination and deciding whether a particular transaction is going to be lawful are really, really quite enormous. And so even though we seem to have reached kind of a plateau in terms of the pace of implementation of new sanctions, the atmosphere remains very challenging for companies who are trying to navigate what's already happened.
And if I can just very briefly, Barbara, touch on one point you made. Also, a number of EU companies are still very active in Russia. And some of them are even requested to do so by European governments, right? So, for example, companies that deliver security components for Russian nuclear power plants. So I think we all in the world have a vested interest in keeping these power plants safe, right? So I think it's really critical, and we hear more than once, please continue delivering, and we'll make everything possible to continue with these supplies. And that naturally also applies to the import, right, of commodities, grains, and metals. So that all that cannot change from today to tomorrow. So I think it's really looking to these companies also a great interest. So even if many companies leave, I agree with you, it's still the big number of companies is still active in Russia, and most of them will probably not be leaving anytime soon.
That's right.
Yeah, I think we read where a lot of the big marquee banner names had the big four accounting firms and some of the others decided to pull out, McDonald's and some of the others. But to both your points, there are some necessary functions and necessary goods and necessary items that still have to remain in order to keep the place safe and the lights on and working. One of the areas I think where we've seen a lot of impact and a lot of discussion certainly, and perhaps a lot of uncertainty as well, relates to these sanctions regimes' impact on supply chains. And I think it would be beneficial for our attendees here to hear a little bit about how these sanctions are impacting supply chain and potentially some of the responses that could alleviate or address some of these restrictions. And I'd like to start with you, Roland, in the EU, and hear your thoughts on that, if you will.
Yeah. Okay. Thank you for that. And I think it's a complex question, right, with many shifts. And I think it's the one issue is dealing with the persons that are on lists, right? I think the SDN is one of the big US lists, but we all have different sorts of lists, and here in the EU as well. So we've seen this list being expanded very frequently. Now we have big names such as Abramovich, Mordashov, Usmanov, now being added to lists in the EU. But I think it's really important then to look precisely on what list we are talking about. So these gentlemen I just cited, they are on a list that refers to making goods or economic resources available to them, right? So that's, I guess, the biggest list from the number of persons you talk to. But then there are other tables dealing with, in particular state-owned companies that are subject to a total transaction ban. So, for example, Kamaz or Gazprom Neft, from an EU perspective, there is a total prohibition of entering into any business with these persons. And then we have other lists dealing with purchase, sale, and provision of investment services that relates, for example, to a number of banks such as Sberbank, Gazprom Bank, I think all major Russian banks. And while we're speaking about banks and they have a big impact on supply chains, there are a number of sanctions specifically dealing with the financial sector, such as granting new loans and credits to persons in Russia, excluding Russian banks from SWIFT, which I think in practice had a huge effect, more than a number of specific targets. If you take the possibility for people to move money around, it really makes it difficult for them to sell products anywhere. And then actually we had the prohibition on public financing and investing in Russia, which also made it difficult to have their new green or brownfield projects. If we look from a company's perspective, what we see is that the companies have an interest in coping with EU sanctions, with US sanctions, UK sanctions, Japanese sanctions, and so forth. But even one type of sanctions is really enough to keep more than one person working on that. So really the difficulty is how do you do that in practice, and that's aggravated by the fact that as Sue and Barbara were telling, we have 50% ownership or control here in the EU. Rules that even broaden the scope of the sanctions that could affect any supply chain of these persons. So what you really have to do is to screen the entire ownership structure, and if at the end of the day you have a sanctioned person that owns a mining company, then essentially that blocks you from acquiring these these metals. So how do you deal then with these issues in practice? How far do I need to dig into the supply chain? And I'm really sorry for that, but I have to provide this lawyer's answer. Well, that depends, right? Because you really have to look into how difficult is the case you have, how many red flags are touched, and the more red you have, the deeper you have to dig, right? So, and naturally, and Barbara will be speaking about that, you will see that in an M&A transaction where it's really a lot at stake, you will need to dig much bigger than if you're simply buying, a car where you know that there will be some palladium in this car. So it's really a question of a risk-based approach will tell you how much you have to dig. And I think on method-wise, I think it's nowadays impossible to screen, unless you have very limited operations, it's impossible to screen that manually. I think it's really a key to have a electronic screening, and there are all sorts of service providers that take that over. I think it's really, given the amount of persons on these lists, I think it's really, I would say, it would really be a risk if one doesn't screen that electronically. And then, so this on the practical screening side. I think David, just perhaps one or two examples on sectors that we have seen that are particularly targeted on the supply chain issues. One is with regard to metals, and some of the metals produced in Russia, but also in Belarus, are really key to the industrial processes that we have here in the electronic business, but also, when you look at renewable energies, you need all these solar plants, all these, windmills. They need some of these precious metals that are sometimes produced, 70%, 50% of them are produced in Russia and Belarus. So I think here countries have tried differently to still allow these imports to happen, right? And we've seen that some persons owning these mining companies are listed in some lists, but not in others. And somehow, I think the importing authorities still make it possible to buy, this palladium, the nickel, the aluminum from Russia, allowing the companies here to move on. I think another big issue turns around transportation. The EU has banned freight forwarders from to move to and from Russia, and that applies really everything on the transport side. So I think on practical terms, it's quite difficult to move stuff around, and that's really one issue that makes it difficult and makes it more and more difficult to keep the supply chain up and running. And lastly, one issue that we see more and more frequently with regards to not only looking at these sanctions on a risk perspective, but also on the chances. I think here we see a lot of investment either already being made or in the process of being implemented, and that's with regard to changing the supply chains. So we've seen a lot of nearshoring happening, new facilities being constructed in the EU rather than now in Russia. And I think if you look at mining, certainly, there are some countries, an African country or Australia, that will definitely benefit from the divestiture from the Russian mining business. And I think, but also in the construction business. So I think that's really going to be a new scene of people moving their business around, right, to nearshore or to other shores. But here again, I think it's in these changes of supply chain, it's the regulatory scheme doesn't make it easier. With all these supply chain schemes, we'll really look into whether human rights are being violated or not, and that will certainly be less of an issue in Scandinavia than it will be, for example, if you're digging for special metals in some African countries. So that can be a role here. Just today in the European Parliament, a regulation was passed in first reading, prohibiting the import of products from deforested land. So I think that shows that here as well, while we have the sanctions on the one side, the regulatory one, that other regulatories are, putting pressure on the supply chain as well. I think two last points here. I think the EU, at least from a theoretical perspective, is trying to avoid trade restrictions and reduce costs on technical barriers to trade. At least that's what we hear is being said. Well, we haven't seen that so much in practice yet, but at least I think there is a conceivable try to limit these bottlenecks to make it possible to import products that would otherwise be tainted. But I think I guess it's still an area where we need a lot of improvement for that to happen. And I think, yes, that's my thoughts on the supply chain issues.
Thank you, Roland. Barbara, what are you seeing from the U.S.? What is the U.S. encouraging in terms of managing these supply chain issues as they relate to Russia?
Sorry, just making sure I'm not on mute. Yeah, I think in general terms, the types of supply chain impacts that are that Roland discussed are happening here in the U.S. as well. Albeit some differences of degree around the edges. But what I wanted to comment on really is just this whole sort of trend. At one time everything was all about offshoring, and then we started to talk about nearshoring and friendshoring and reshoring, and this is a trend that I think really started during the pandemic, because don't forget that these supply chain issues that are happening as a result of the Russia sanctions are sort of layering on top of a lot of disruption that really hadn't gone away, that had resulted from the pandemic. And so we've got this building sort of groundswell of disruption. And I wanted to zero in on this idea of nearshoring and the rationale for it. One commentator has said that, and I'm just going to read this, the idea is for a group of countries with shared values to deploy policies encouraging companies to spread manufacturing within that group. And the goal is to prevent less like-minded nations from unfairly leveraging their market position in key raw materials, technologies, or products to disrupt the US economy or those of its allies. Now, Roland was talking a lot about raw materials. I mean, a country either has natural resources or it doesn't. And in many cases, there are rare sources of natural resources that are key to many types of manufacturing. So I'm not sure how governments in trying to band together and come up with new trade agreements are going to assess those issues if they're starting to think about things like supply chain security and tie that in somehow to negotiation of trade agreements. And even if you could do that, things change. And don't forget that, we had in 2012, we have Russia ascending to the WTO. Fast forward 10 years later, we have Russia losing its most favored nation status and countries imposing tariffs against Russian imports that are sort of back to the pre-WTO days. So how this is all going to play out over time in the context of trade agreements, I think, is going to be very interesting.
Thanks, Barbara. And Sue, there are some unique issues as it relates to supply chain within the UK. Could you talk a little bit about those?
I guess what I would say is I think the trend there's a much more definite trend in the UK than perhaps is playing out in the EU and the US to exit the Russian market entirely. I see, the clients that I'm advising are all around how to get out and not how to legitimately stay, because I think part of the issue is around reputational risk. We have had law firms being named in Parliament for representing Russian parties, which I think is just an extraordinary state of affairs.
Interesting. Yeah, we've had discussions internally about, and I'm sure you all have too, of clients coming to you and desiring to get off a list or trying to understand why they're on a particular list, and the risk committee involvement and how we decide whether or not to take on those matters and what we consider when we do that. And it's generally a flat out no. Before we move on, I did have one question, and while none of us have anything to sell, does anyone have any ideas for screening tools? Is anyone familiar with any, commercially available screening tools that are available to help screen supply chains? At the higher ends, I'm sure we all do some level of due diligence, and we're going to talk about that shortly. But is anybody familiar with any of the screening tools? Because I'm not, and I have been asked.
Do you want me to just sort of jump on that very quickly?
Please.
We've certainly seen a lot of these different third-party screening softwares in action, so to speak. And whilst I'm not going to name and shame those I don't like or advocate for those I do like, I will say that one of the key things that many companies don't realize is that how you calibrate your third-party screening software is incredibly important. And if you utilize settings that require a very low percentage match, or that eliminate hits on common words, over the years I've seen almost every kind of thing that could go wrong in terms of compliance personnel not really understanding what the capabilities of the software are and how they can tailor those and what the implications of tailoring settings will be in their particular circumstances. So certainly for any company that has a very high volume of transactions, you know, these third-party softwares are almost a must. But at the same time, it really is a kind of buyer beware, and then, you know, educate yourself about how to deploy that software successfully.
Yeah, I completely agree. I think it's a tool, right? It's a powerful tool, but you have to know how to use it, right? At the end of the day, you need to have the, you know, the compliance people or the trade people, whoever, you know knowing how to deal with that, and then if you have a hit, of knowing how to deal with it, right? And I think that's really so. You know, it's not sufficient to have this tool, but it's important to have it.
So before we move on to some of the regulatory developments and some of the guidance, if I could quickly go around the horn real quick and ask, you know, a function of the technology and the use and the people is a risk assessment. And we know the importance of it and we preach it, but query whether, we can start with Sue and go around, but are you being asked to assist with those risk assessments and help guide clients on what those should be, and are clients actually doing them?
I guess my first point is one around legal obligations and the assumption of duty. I think lawyers have a natural concern about assuming duties of care in relation to advice about, you know, how much is good enough. In the same way, I'm basically echoing Roland's point, which is how much due diligence should you do? It's a risk-based assessment. What I would say is we use one of those tools, or maybe two of those tools, and you can get very many hits which are irrelevant, but you have to know, the people that we employ in the compliance group have to have that knowledge to know whether they're relevant or not. And I think the other point that I would mention is I've acted for an individual who was no longer designated, should never have been designated, and yet years later his name still shows up on the screening tools as a red flag.
Barbara, risk assessments, are you being asked to assist with those?
Yeah, I think that's right, and I largely echo what Sue said. Maybe just a couple of quick additional points. One is that that risk-based assessment is really one that the client has to make at the end of the day. From the lawyer's perspective, it's our role to explain the legal risks. It is the role of the client to weigh those risks, and so I don't think I can add any more to that.
How about you, Roland?
Yeah, I think, if you look at the German economy has been extremely, tangled, with the Russian economy. So we've had a number of big companies, from all sectors that were very active in Russia. So I think we had a number of cases where we had to discuss with clients whether a supply chain can be, upheld, or in particular, when it gets really difficult is, divesting from a joint venture with a Russian company. And that can be rather easy when your Russian JV partner is on the total transaction ban list. So then you have to get rid of this investment. But there are other cases in which you for reputational reasons or for other reasons, because compliance is too expensive, as Barbara was saying, you decide to dissolve this JV in Russia. and that's really really complicated. You know, at the end of the day, you don't want to, you know, just give away your participation, but that's what some of the clients had to do, you know, really based on the risk assessment where it wasn't possible to do anything else.
Great, thank you. Moving on a bit toward sort of regulatory developments and compliance around these sanctions, the Treasury Department, as they have for years, cranks out frequently asked questions. I think there's over 1,000 of them now on their website. 100 of those are new since the invasion of Russia. The EU has a website called Restrictive Measures Explained, which I think is the other end of that, which might be 1,500 words, and by all accounts, maybe a little thin. And so we have these inconsistencies. We have thin guidance. I'm going to ask Sue to talk a little bit about, you know, sort of navigating these, and how do you begin to advise your clients of all these, and where in the UK do you look for information and support?
Again, it's complicated. So OFSI is responsible for the implementation and enforcement of financial sanctions, what we know as designations resulting in asset freezing measures. It's able to impose civil monetary penalties for breaches of financial sanctions and criminal penalties if it considers that it can meet the criminal standard, i.e. that the defaulter knew or had reasonable cause to suspect beyond reasonable doubt that it was breaching sanctions. Convictions can lead to fines and imprisonment for up to 10 years and includes the possibility of individual criminal liability being imposed on the directors, officers for corporate breaches. In the civil context, these are now civil strict liability, civil offences, so to speak. And that was introduced by an act called the Economic Crime Transparency and Enforcement Act, which came into force in around March 2022. What's notable there is the Sanctions and Anti-Money Laundering Act took 9 months to go through Parliament. The Economic Crime Act took around 9 days. What this means is that OFSI no longer has to show that the defaulter knew or had reasonable cause to suspect that they were breaching sanctions. In other words, the mens rea element, the mental element or mens rea of the offence has been done away with. So OFSI can now impose fines or name and shame on the basis of strict liability. There's a different regime for breaches of trade sanctions. There doesn't seem to be any mechanism for the imposition of civil penalties and query the position re strict liability. The government has stated in the past that a particular section of the Customs and Excise Management Act 1979, that's section 68(1), is a strict liability offence, but that only relates to the export of goods in breach of prohibitions. And Roland has already discussed some of the importation prohibitions which apply in the EU and also in the UK, subject to the UK's own domestic legislation. So DIT, ECJU implement and enforce the trade sanctions. HMRC, Her Majesty's Revenue and Customs, and the NCA, National Crime Agency, appear to be the bodies charged with investigating criminal breaches, but they would then refer to the CPF. Conviction can lead to fines and imprisonment of up to 10 years, and again includes the possibility of individual criminal liability. Now, unhelpfully, OFSI's default position is not to provide much, if anything, in the way of guidance. For example, they'll say it's the responsibility of the applicant to determine whether a licence is required. If in doubt, seek legal advice. For a period, OFSI actually appeared to adopt a more helpful stance, but they now seem to have resigned from it. There was a seminar on the 5th of September, so just last week, where Giles Thompson, the director of OFSI, basically said that they discouraged speculative licence applications. And that was an odd position to adopt in circumstances where the OFSI has issued, together with another body, a red alert highlighting transactional red flags, which actually recommended firms to seek guidance from OFSI. Plus, they've been very slow and have walked away from their own service level guidances. Now, though, to be fair, they are overwhelmed. At the same webinar, the director of OFSI explained that the number of license applications that they had been receiving had doubled, if not quadrupled, since Russia invaded Ukraine. So what we don't have that the US does have is a basic, a telephone line where you can contact OFAC and ask for guidance on a no-name basis. We don't have that in the UK. The position of the ECJU is a little bit more helpful, actually, at least in my experience. And they're the guys that really take control of trade sanctions. There you can contact them, and in my experience, you'll get guidance within a day or two. So I think there it's much more helpful. And I don't want to tread on Roland's toes, but I know that the EU has also issued guidance stating that it's the responsibility of the individual competent authorities in each member state to give guidance on whether or not a particular transaction or fact pattern breaches sanctions.
Roland, you want to jump in here? It's a perfect segue.
Yeah, and I think it's really, the complexity on the regulatory side in the EU is really, hard to beat, I guess, because we have, 27 member states, each, transposing the rules that the EU has set. So basically we have the umbrella, on umbrella level, the EU, setting the rules, but, as it is transposed into practice, that's up to member states. And then in Germany, for example, we have two authorities dealing, one with the goods and one with the financial sectors. So it's really, and you have similar splits in number of member states. So there's really, you have like a big puzzle of who gets involved in sanctions here. I think what we are seeing is that perhaps more in some than in other member states, that there's quite an activity on the criminal enforcement and seizure regarding Russia sanctions. So we've had some high-profile cases here, one in Germany on the chemical side for alleged breaches, and we also have a number of clients dealing with alleged infringements of the Russia sanctions. So I think authorities are really treating this matter very seriously and perhaps more than they have done with the Iran sanctions before. So that's really something that I guess will keep the companies quite busy in the next few months. With regard to confiscation, these were the cases where that made it to the press, where you have Mr. Usmanov's ship being hauled in Hamburg. He's saying it's not his ship, but that's what you see in the press. So I think there, that's also, I guess, nice for authorities to be able to show that they have confiscated a big ship from a rich guy, right? I think one issue, Sue, that you briefly touched on was, on how are these EU rules applied? So they certainly apply in the entire EU. And the EU, at least with regard to Iran, kept on saying that the EU is acting illegally because it's applying these laws extraterritorially. Well, in practice, the EU is doing pretty much the same with regard to the EU sanctions on Russia and also with regard to Iran, because the rules apply to every transaction concerning an EU person or an EU company. It happens that basically all EU persons, including subsidiaries of these persons, in practice have to follow the rules applying to their EU parents. So I think it's perhaps not as strict as in the US, but Barbara, I guess you'd be able to explain that much better. But I think in practice we have a number of subsidiaries of EU parent companies which are in theory not required to follow the law. They need to follow the law because they require financing from their parent companies, because they require guidance, compliance checks, and also so forth. So they end up applying EU rules also at their subsidiaries in China, India, and so forth.
I think that's right, Roland. And in the UK, and I know it's the same in the EU, every single UK person, wherever they are in the world, is in theory bound by the sanctions. And so I think the heat that perhaps the US has got from exercising an extraterritorial reach is a little bit unfair, because each of the relevant regimes exercise a degree of extraterritorial reach.
Yeah, I think that's right. And certainly, even in terms of, I recall when the UK Bribery Act came out, I think we were all a little surprised at the long arms of the UK as it relates to that. Barbara, the US perspective in mens rea and liability, how does it work here?
Sure. Well, maybe if I may, I'll start with extraterritoriality, because Sue is quite right. This citizenship jurisdiction is a perfectly legitimate, globally recognized theory of extraterritorial reach of a jurisdiction's laws. And so all of these jurisdictions that we're talking about have sanctions laws in particular that follow its citizens, in our case, U.S. persons, which includes a few folks who aren't citizens and includes companies incorporated here and so on. I think the most widely criticized sanctions programs certainly an EU and UK perspective have been the Iran and Cuba programs, which purport under US law to extend the restrictions and obligations of the sanctions programs, not only to the set of US persons, but also to companies in the EU and elsewhere that are owned or controlled by US persons. We don't have that loss in the context of the Russia sanctions, but as Roland alluded to, we do certainly, because of the citizenship jurisdiction, have to be concerned about the parent company facilitating activities that it can't perform directly. We have to be concerned about U.S. persons who may be working at or in companies around the world, subsidiaries around the world, who can't be involved in particular activities and so on. So, so that citizenship basis for extraterritoriality does play very much into the Russian program as well, albeit not quite as intrusively as in the Iran and Cuba cases. From the U.S. perspective on various theories of liability, as in other countries, we have, whether it's OFAC, DDPC, BIS, Customs and Border Protection, a lot of different agencies involved in enforcing these sanctions, but all of the laws and regulations that authorize the jurisdiction of these agencies have always, in the U.S., had both a civil penalty component, a strict liability civil penalty component and the sort of intent-based criminal prosecution potential in the event that one willfully violates these laws and regulations. And so, as a result of that, in both the sanctions and the export control context, we've seen, I would say, most of the cases tend to be civil enforcement cases, and many of those cases do involve very substantial penalties, even though those are civil penalties and not criminal fines. Now, one development, though, that is particular to the Russia sanctions buildup is the fact that in early June, the Export Administration Regulations were amended to allow BIS to make public charging orders under its administrative civil penalty process. Previously, it had been their practice not to make these orders public unless or until the case was settled or otherwise adjudicated by an administrative law judge. And so on June 6th, we saw the first exercise of this authority when an administrative charging letter was issued against Roman Abramovich. And that had to do with alleged violations relating to a U.S. origin aircraft, and that led to seizure orders being issued, seizure warrants being issued in that case. Now, the other sort of interesting element of our enforcement system that is kind of highlighted by this case is the way extraterritoriality is evidenced in the context of our export control system. And there it's slightly different from the sanctions programs, which sort of follow the person, if you will, the company or the individual. The export control laws follow the goods. And if I can be permitted a brief Latin phrase, this is sort of a quasi in rem remedy. The key is that the goods are subject to the EAR, quote unquote, and therefore our laws apply not only to exports from the United States, but to re-exports of those items that are subject to the EAR from one third country to another, or even to transfers within a third country to different end users or for different end uses. And so we've seen a lot of publicity around, especially in the aircraft space, around these kinds of cases, because once an aircraft is of U.S. origin, it's subject to controls now for export to Russia, and various, in fact, most of the parts related to maintenance of that aircraft would likewise be subject to controls. And I think the other thing that has been kind of highlighted here in the context of export controls and extraterritoriality is the fact that there are various categories of foreign produced goods which can be subject to our export control laws. Most people are familiar with the de minimis rules, under which commodities produced outside of the U.S. can be subject to the EAR and subject to our export control rules if they contain the requisite amount of controlled content. And we also have something known as the foreign direct product rule that kind of, until recent years, sort of languished in obscurity, and now has become very much front and center. We now, as a result of the most recent amendments in the Russian and Belarus context, have a total of 6 different iterations of the foreign direct product rule, 2 of which are specific to Russia and Belarus. And so companies who had not previously had to be concerned about whether they had controlled content or were producing goods for Russia with controlled technology are now having to sort of get into the intricacies of these rules and try to understand them. And then finally, the other sort of idiosyncrasy, which I don't think has an equivalent, but I'll stand to be corrected by Sue or Roland, I don't think has an equivalent in the EU or the UK, and that is our General Prohibition 10. This is a prohibition contained in the export control or the export administration regulations, excuse me, which deals with and makes it a violation to proceed with a transaction with knowledge that a violation has occurred or is about to occur. And if that's the case, so if you have, for example, an aircraft that has been unlawfully re-exported to Russia, then any transaction related to that aircraft, if you have knowledge of the violation, and it's a very broad list. I'll just read. You cannot sell, transfer, export, re-export, finance, order, buy, remove, conceal, store, use, loan, dispose of, transport, forward, or otherwise service in whole or in part. So very, very broad prohibition, and that is definitely one that is being utilized by our Office of Export Enforcement in the context of the Russia sanctions. Back to you, David.
Thank you. I'm looking at our time. I'd like to jump ahead to an area that's near and dear to my heart, and it's an area where regulators have suggested a step up in intensity, frequency, and I'm sure the panel is seeing that as we are, and that is due diligence, where red flags are no longer simply red flags. There's a lot behind that. And what are we advising clients that they need to be aware of in order to be, more strategic about their approach to M&A and the retention of third parties? I'm going to start with you, Barbara, if that's good.
Sure. Well, this is a subject that we do a lot of work in this area, and in fact, one of my colleagues and I have written a chapter for the Global Investigations Review Guide to Sanctions on this very topic. And interestingly, we chose to focus, and all of this work was done and written before the Russia sanctions started to come to the fore again this year, where we recognize the importance of not trying to do the so-called sanctions due diligence in a vacuum, but rather to recognize the way in which the sanctions and export control due diligence and even frankly import looking for import violations are inextricably related now, because these tools, whether they be export controls or sanctions, are being used more and more by our various governments in tandem to achieve various foreign policy goals. And so there's really sort of two types of due diligence that is really important. Roland has touched on the so-called transactional due diligence. In other words, sort of KYC, know your customer, try to make sure that a particular transaction that you're about to embark on is going to be lawful. And so, in that context, we have this sort of 50% rule, which requires aggregation of parties, the ownership interests of parties subject to like sanctions. So if you have, two SDNs owning together 51% of a particular company that's not on the SDN list, you have to treat that company or prospective business partner as if it were on the list. Unlike in the EU, though, our rule doesn't extend to control. Although in that respect, I think the position of OFAC is, and frankly the export control agencies as well, is a little more similar to the EU position, which is that, you know, if parties are acting in concert, then you do have to look at the controlling, the identity of the controlling entity. Although, you know, sort of for different reasons, because, you know, we have laws that make it an offense to aid and abet an export control violation, or aid and abet a sanctions violation, or conspire to commit one of these violations. And, you know, so in that regard, you know, certainly you have to be aware of, and as Roland so colorfully said, if I may repeat, you know, the more red you see, the more problematic the situation becomes, and the deeper you have to dig. But I think what this illustrates is that across all of these different laws and regulations, there are so many differences now. Our lists are not the same. Our policies in relation to how to apply the list is not the same. And as a result, you know, the days are gone, assuming they ever really truly existed, where companies could say, well, you know, the US regime is always going to be the most restrictive, and so we're going to follow that, and that will catch everything else. Well, that's just simply not the case anymore. And so it really becomes a very complex undertaking to conduct this KYC due diligence, and certainly is probably, you know, the time consuming nature of it and the cost of it, because when you do have to go out and sort of do ownership due diligence, that can be expensive as well, because you have to get third parties involved. The information is not always, and particularly in the Russian context, not always publicly available. And so really important to do all of that screening and due diligence on a transactional basis, as well as in the M&A context. And, you know, one final point in terms of this sort of transactional due diligence is the fact that the screening tools that you're using, you know, let's not just focus on sanctions, because at least in the US, our export control laws do have their own lists, such as the entity list, or the denied persons list, for example, which put various companies and individuals kind of off limits to transactions involving items that are subject to the EAR. You know, from an M&A perspective, you know, we've all been faced with various iterations of bans on new investment. There are bans on, you know, sort of accounting, corporate formation, management consulting services, which make it not only difficult to manage a business that has a component in Russia, for example, but certainly if you're looking at a target company that owns businesses in Russia and trying to do due diligence, you can understand why if you can't export management consulting services to Russia, it becomes very difficult to even conduct the due diligence in the first place. So there's a lot of implications there, and never mind the sanctions due diligence. You know, because there's all the other aspects of due diligence, including accounting, for example, and looking at the management structures of companies and so forth, and trying to determine whether this is a good investment. So a lot of red flags there. I think I already mentioned that, you know, although we don't have the same kind of extraterritorial reach with the Russia sanctions as we do with the Iran and Cuba sanctions, we do still have to be paying attention to concepts like facilitation and aiding and abetting of export violations, and even the banks. Somebody mentioned financing earlier. The banks are becoming very cautious. Not only they've been cautious for a long time on the sanctions front, and I think they're also becoming very cautious on the export control front as well, and looking very carefully at what kinds of transactions they're financing.
Roland or Sue, any additional due diligence tips from your various perspectives?
Perhaps no tips, just, I think we're seeing the same issues here in the M&A. And, even though it's also, a corporate activity, but, it has its own rules. That's regarding IPOs and, funding rounds of startups, where, we have millions and billions of euros, US dollars, whatever currencies you want to have of Russian money in big startups here. And every financing round you make, you have the issue of how do you know if one of your investors, and because naturally you hardly have any natural persons, you always have a fund which is invested in another fund. So that's really makes it extremely complicated. At the end, you always end up in Cyprus or other beautiful islands, and it's really difficult there to find out who owns that money, right? And that's really, I think, will probably be the, keep us all busy for the next few months, trying to look who owns really these companies.
Well, that's absolutely right, and I'll tell you just a very quick aside, because it's not really the topic of this webinar, but the U.S. rules on foreign investment review, and of course you have them in Germany, and the U.K. has a new regime as well. All of these in our rules are very much tied to whether there are, among other things, whether there are export controls applicable to particular technologies that the U.S. target company is engaging in. So all of these, you start to pull the string and everything quickly unravels. So I don't know if Sue had anything she wanted to add.
No, I don't. I'm conscious that time is running out, so I thought we'd move to, sorry, David, I'm in risk of doing your job now. But I thought we would perhaps deal with, what comes next, which was one of the subjects for, and it's in the title.
Yeah, let's do it. The crystal ball, as we look to close, what is yet to come from each of your perspectives, and what do you see down the road for your clients? And Sue, if you'd like to start, that'd be great.
Yeah, fantastic. I think first of all, I see a lot more sanctions, and I think we were given a hint of that by Giles Thompson, who, as I said previously, is the director of OFSI. He said that he was looking to build his team from 45 to 90 by the end of the financial year. And I think that's a sign as well that they're looking at more enforcement type activities. And the other area that I think we probably all agree is an area of concern, certainly in respect of the operation of the rule of law, and also in relation to the orthodoxy of sanctions and the theory behind them. The press has made a very big thing, and actually so has various governments, have made very good big noises around confiscating seized assets. And as far as I can see, there's no basis on which that in which that can currently happen under the current sanctions regime. And it is a concern to me that we would be contemplating doing that in circumstances where the theory of sanctions is that you impose them in order to change behaviour. They're suspensory in effect. And once the behaviour has changed, you remove them. And clearly, if we're confiscating assets, that can no longer happen. And so that's an area of concern for me.
Mm-hmm. Roland.
Yeah, it's certainly also a topic at issue here in the EU. I think one of the topics that we are, heavily discussing with clients, it's China. So will China be the next target of Western sanctions? I think, one issue, this may be a result of Chinese companies taking over business of Western companies in Russia, right? As we've seen, Western companies leaving Russia, so there is a empty market. And if we look at the automotive sector, 24% of the new cars sold in Russia are now Chinese, 21% are Korean cars. So I think that could lead up to, an appetite for the EU, or in particular the US, of trying to target these companies. And I guess this would be hard to swallow because, I think, the economy isn't that great in some of our Western, at least the EU countries. And I guess the biggest issue by far would be, a potential aggression from China against Taiwan, which would certainly, cause sanctions. But if we are considering the implications of Russia, that would be nothing, right? I mean, considering that basically all the chips that we use worldwide are produced in Taiwan. So I guess that would really, be a huge game changer. And I think here in Germany, everyone is afraid of, when this could happen and what the response would be. So that's really, if you see all the risk scenarios being built at the C levels in the companies, that's all around China.
Yeah, that would really seem to between Russia and China, that would really seem to close down a lot of avenues for production of a lot of things. Barbara, your crystal ball question.
Okay. Well, I certainly agree that the rule of law issue is a troubling one. I don't speak for UK law at all, but in the US, we certainly, under the sanctions laws, have a very similar approach to what Sue described vis-a-vis the UK. I think one difference being in one possible explanation for at least the US government's seizure or issuing of seizure warrants has to do with our criminal law system, which does allow sort of pre-conviction seizure of assets. And again, I'm not a criminal lawyer, but I'm given to understand by my colleagues that there are laws on the books here that do authorize that type of seizure, albeit in the context of criminal proceedings, as opposed to simply a civil penalty type enforcement of sanctions laws. But to close with the one sort of crystal ball question that I keep getting, that I'm frequently asked whether I think there will be secondary sanctions deployed in the Russia context. And I think the answer to that is, I'm going to go out on a limb here. I'm not going to give the usual lawyers it depends response. I'm going to say I don't think so. And the reason I don't think so is because we've had such a multilateral coming together of nations who are concerned about the Russian invasion of Ukraine, and the response has been phenomenally both swift and multilateral, albeit with the differences we've discussed today around the edges. And so and Congress, frankly, this year hasn't, the laws that we do have on the books, 2018, various provisions of CATSA, for example, which authorized various types of secondary sanctions against Russian actors, but then, those were never really acted upon in any meaningful way by OFAC, apart from issuing fairly vague guidance, which caused probably more uncertainty than the laws themselves, and if anything, the impact of those laws was uncertainty rather than actual, implementation of secondary sanctions under those authorities. The only thing that I will say is that I think we will continue to see designations. And, there's, as I'm sure you're all aware, some discussion about whether the ability under these executive orders to designate someone, put them on the SDN list, for example, as a tool of foreign policy is really a secondary sanction or something else. But apart from that, that limited continuation of designations under executive orders, I don't think we'll see anything in the way of secondary sanctions. It's really sort of not necessary because we already have the support of the international community.
Very interesting. Very interesting. I'm looking at the question queue and I don't see any questions, so I am going to selfishly ask a very self-serving question, if I can, of all three of you, because I really query whether the answer is different in each of the jurisdictions. But when you're asked or we're asked to do beneficial ownership research and come up with an answer, one of the questions I think we're always forced to ask is, do you want to know the answer or do you want evidence? Because in a lot of locations, it's really hard to find documentation or paper evidence of beneficial ownership. Is there a, and I'm not going to use the term standard, but is there an acceptable level of information that works short of a Secretary of State document outlining beneficial ownership or some memo or some memorandum of understanding or contract that is admissible, permissible, usable to prove beneficial ownership in the UK, EU, and US? And
So if I were to go first, I would say, short of a designation, no. And if it smells, it smells. And I would be advising clients to stay away.
I mean, it makes sense. Barbara, Roland?
Yeah, I think that's right. I mean, we haven't, I don't think, really seen enforcement cases and published decisions that speak to what might have been required to in terms of the requisite level of proof that a company is owned 50% or more by ultimately owned by and so so in the absence of that, I think the best we can do is sort of see whether it passes the smell test, as Sue says, and look to see whether there are red flags. And even though in many cases information just simply isn't available, there may be, in terms of specific public records that show ownership. Not every jurisdiction, I mean, look at the United States, not every jurisdiction even requires that a company file information about its shareholders in all cases. So oftentimes the information simply isn't there. And what we've found is that if you do utilize services that gather to the best extent possible from public sources information about possible ownership structures, then that either raises a red flag or it doesn't. But certainly if it raises a red flag, then you've got that issue of not wanting to proceed, or presumably the client not wanting to take the risk of proceeding. I don't know if, Roland, have you encountered that as well?
I think Certainly all of these aspects are also true here for Germany. I think what we see in some areas, so for example, with regard to, in the startup area, are some like industry standards. When you look at the questions that are asked, you see a lot of questionnaires that you see more and more often. And we see a number of clients being asked to sign certain, export control clauses, which is, okay, I've seen that before. So I think there is some type of uniformity arriving with regard to standards that are applied, throughout the industry. But that's more, coming from a, you've seen that other people do that, so it must be okay, right? But I think we see that in more and more sectors. But it's not some kind of legislation or case law setting how you need to do that. It's just, how you do that if you talk to your colleagues and you end up doing the same.
Yeah, although I will say that these certifications they're fine as far as they go, but if you have other information that raises a red flag that appears to be contrary to that certification, then you've got a red flag.
Right. Well, thank you. Thank you. I really thought that this was very useful. The information is chock full of nuggets. There are no easy answers. We're all threading a needle in some way, right, with the various jurisdictions and things. And I just like to thank the panelists. You've been incredibly accessible with folks that have questions that we think they should feel free to reach out directly to any of the three of you. And I don't have anything else.
Thank you, David. Appreciate your guidance as moderator.
Yeah, thank you very much.
Indeed. Thanks, David. Take care.